purpose are specified in prevention of money laundering rules, it is often observed that no natural person is identified as the beneficial owner of several FPIs based on economic interest or ownership. Now, Lord, the next page is actually the previous page, page 86, because this is how they had given to us. So that's how we have annexed.
Person need not be the owner. It could be a company also.
No. Ultimately, my lord, ultimately, all companies ultimately are owned by some person.
Correct. But then
Yes.
the person, the shareholder is different from a company.
No, the point.
Jurisprudentially,
So the point was,
a
my lord,
shareholder is not a
so
company.
let us look at the rule. The rule was, SEBI said that no listed company can own
Yes.
that no person or his immediate family, their defined family, can own more than 80% shares in a listed company. Now this rule is being circumvented or can be circumvented if you invest 75% directly through you, then you set up some foreign companies.
Which are the companies?
Foreign
where
company.
there is Circumvention.
So, no, that's what SEBI said in the report.
Circumvention.
So just see, my lord, the Supreme Court committee report.
Correct.
First, my lord, first see this.
There is circumvention.
Yes.
Which are the companies?
No, that's what that full-time member said in that interview. He has said that.
Has he given instances?
He said that out of 5 lakh crores, 1 lakh crores was being used in this way.
Has he given APC company?
Lord.
Why we are saying all this is, we are looking at your prayer. What do you want?
Lord.
Disclosure. For what purpose?
So my lord,
what purpose?
World Bank, ADB, Transparency International, each one of them.
What are you going to do after that disclosure?
Then only, my lord, can these people who are circumventing our financial regulations by investing more than what is allowed or by doing other things, only then can that be detected.
But where is the, first of all, there has to be detection.
Detection will.
Detector. You want the court under article.
So see, my lord, the Supreme. So first.
We are concentrating on your prayer.
Just see, my lord, this report.
Concentrating.
Yes, my lord.
On your prayer.
I'll come to that. Just come to page 230 again. This is the Supreme Court Expert Committee report.
Please see your.
Just see.
See your prayer.
Yes, my lord. Prayer.
Issue a mandamus.
Yes.
Asking the SEBI.
Yes.
To mandate full disclosure.
Yes.
All right. What are you going to do on that?
That then only, my lord.
For what purpose you want?
So the purpose is. The purpose.
You are making use of this article.
The purpose is specified.
As a Right to Information Act.
No, my lord. The purpose is clear from the report of the Supreme.
You detect. Then you say there is violation. Then you seek appropriate writ.
But my lord, unless I know.
Violation, take action.
Unless I know.
Do not know. Nobody knows.
So because they are not.
You are asking a right to information.
That's what the Supreme Court committee said. Expert committee. Just see that. Yes, they have identified the problem. No, not companies. They are saying that SEBI was investing.
Concentrating. Can such a writ of mandamus be issued? That is what we are under Article 32.
Yes, Lord.
Our writ of mandamus must be for what purpose?
So the purpose is.
This is a public interest litigation.
Yes, my lord. To stop.
Say asking. See, we are just putting it to you so that you come out. You can't have an Article 32 petition, which is in the nature of a right to information.
No, this is not right. Of course, right to information is also a fundamental right recognized by the court.
Not Article 32 like this.
No, it is the Article 19 right.
Entertainability of a PIL.
Similar petition was made in Vishal Tiwari. It's a reported judgment. My learned friend appeared as one of the petitioners, and this issue is covered that we cannot regulate. What are the regulatory measures?
No, we are concentrating on the prayer.
That was the prayer.
No, that is not the prayer.
Whether such a prayer.
Not the prayer.
After this expert committee.
So your lordship may hear me.
On enter.
I'll answer your lordship's questions. So, my lord, the right of an Indian investor today,
See, we understood what you're,
Today, my lord,
what you're driving at, we understood.
35
You are
crore
saying
people,
there may be violation, but you have not given which company has violated.
Lord,
It's a very vague thing.
unless
There is a violation.
unless
Let them disclose.
unless there is disclosure, how will I point out the violation? I am saying
You bring out concrete cases of violation and seek.
so, my lord, when one ostensible case of violation was brought before the court,
Which was that?
that was that Hindenburg Adani matter, and the court appointed an expert committee to go into that. That report, that's what I was trying to show to your lordship. What does that report say?
This is a very general prayer.
So
Maybe should-
that report will show your lordship why that general prayer is required. That report will,
That is after that report. In
that-
this petition.
that report,
was
that report will show why such a prayer is needed in this country today.
See, we will put it now more straightforward.
Yes.
It is a very vague prayer you are seeking.
No,
Why
it's
should
a,
we entertain it?
it's a very precise prayer.
No. Public disclosure should be made.
That was there earlier. SEBI rules required such disclosure earlier. That was done away with. That's what this Supreme Court committee says. This was there earlier. It was done away with. And it was done away with disastrous results. The result of doing away with that rule was that it became impossible for even SEBI. Forget me, my lord. I am a citizen.
Correct. Therefore, how should your prayer be made?
So, my lord, I am saying that
That disclosure, according to you, was done away with.
was
Done away. Or they.
done away with, yes.
Done away with.
Done away with, yes.
All right. Now, what should be your prayer? Then it has to be brought back.
Yes, that's what I'm saying.
Then there must be some material for that.
Material is this.
A common, a generalized.
Material is
submission
this,
cannot
my lord, that because of doing away with that regulation, the result was that it became impossible even for an institution like SEBI, armed with all the investigative powers, to investigate such matters.
This is why the initial point, that September letter reply given to your
But
representation.
you are not supporting it with
SEBI very
documents.
specifically made no documentary evidences place. Of course, you had stated in your
Lord,
representation.
how can I get, suppose there is no disclosure? Suppose there is,
How can-
as there is no disclosure, how will I get without disclosure? I am a citizen.
Then you have no case.
No, my case is that the expert committee which went into this by examining everything, all the rules of SEBI, all the regulations of SEBI, stated in so many words that this requirement was there
Mr. Bhushan,
and it was done away with.
This kind of a prayer.
Yes.
We are saying roving and fishing inquiry cannot be done.
It's
under
not,
Article
I am not asking for any inquiry.
No, we are saying.
I am not asking for any
We
inquiry.
are saying that disclosure. Can such a prayer be entertained by us under Article 32?
All right, my lord, what this court do, say in that ADR matter, when the ADR came to this court saying that these election candidates who are contesting elections, they should be asked to disclose on affidavit their criminal antecedents, their assets and liabilities, and their educational qualifications. This court, under Article 32, using Article 19 and 21, mandated that disclosure. They said that this disclosure is
So
essential.
they do that process. They mandated
Yes.
disclosure. Here, you are asking us to issue a direction
Yes.
to disclose.
We are saying,
Why? How can we?
same thing we are saying, that the,
That is not
that,
a
that
correct
the, that
analogy.
the, no, my lord, with great
With
respect,
respect to you,
with great respect, my lord.
great respect to you, that analogy.
And then they
cannot-
brought a law. They brought a law to override that. Anyway, my lord, let me make my submission. Thereafter, it is of course your
No,
lordship's
yes,
wish.
that is why we are saying even reading this prayer, may have,
So let me, my lord,
may have the, to see the plea to say that such a prayer has to. be
your lordship may
entertained.
just give me
But
10
our
minutes.
doubt is entertainability
All
of
right.
such a.
So
prayer.
let me, my lord, first,
At least if you challenge that reply, then we can take up the issue on merits even. We can go.
reply is a
technically-
reply, my lord. It's not a statutory rule or any statutory response.
No, we asked you to file an amended petition to challenge that reply.
Lord, replies are not challenged.
No prayer made.
Replies are not challenged.
Why not?
This is not a statutory reply.
That itself it
I
would
have-
added something.
Your lordship asked me to first make a representation to SEBI. We did so. Then your lordship asked me to, then they filed the reply after we had filed the second petition. When the reply was filed, we brought it to your lordship's notice. Then your lordship said amend the petition to put that, make that
Yes.
reply. We have amended the petition.
But also challenge, we said.
Lord, what will I challenge in the reply? It is not a statutory.
Supreme Court appointed committees, opinion, views, etc. are before you.
Yes.
When that is not taken into consideration by SEBI, is it not a matter-
Considered by this court and
No, according
rejected.
to him, according to him.
It is considered by this, Lord, this court appointed a committee.
So-
Report was considered and in a reported judgment, it is rejected. This prayer is rejected.
Anyway, my lord, let me make my submissions. Let me make my submissions.
You have understood what you are actually aiming at,
Yes.
but this is not the mode to ask.
So your lordship,
Disclosure.
your lordship can tell me what is the mode
Can't
and
advise
I will
you
do
so.
that mode. When your lordship said incorporate, first give a representation, we gave a representation.
Challenge.
Your lordship said file the SEBI reply and amend the
Why
petition.
not challenge it?
Because, my lord, it's not, it's,
Instead of giving you some.
if I had challenged it,
Some.
then I could have been asked.
The last occasion also we said
Yes.
so. We wanted you to challenge that. When it is not.
I
meeting
can
the
certainly
legal
challenge
requirements.
it. There is no difficulty.
Please challenge.
All right, we'll challenge it.
Learned counsel for the petitioner submitted that you would file an application seeking amendment of the prayer column of the writ petition, hence adjourned,
Of the amended writ petition.
of the amended writ petition, hence adjourned.
Your lordship may give a date. But may I request your lordship to,
Yes.
His case is,
all the
please direct
supporting
them to make it public so that I can fish out something based upon which I can file a petition.
We are not saying.
This was precisely the case argued by him before another bench, which appointed that committee. And my lord, it is rejected.
that was,
That we cannot direct them to amend the regulation
That-
to make something public or not to make.
Concentrating in the writ petition filed at Article 32, which is styled as a public interest litigation. The prayer column is the one which we have to see first.
I also see
Whether
that.
such a prayer can be granted or not.
All right, my lord,
then
I will,
Whether they. then
I will produce,
cannot
I will
grant
produce 10 judgments of this court, at least 10. I'm now making the statement here and now. I'll produce 10 judgments of this court where exactly such a prayer or a similar prayer was not only considered but granted by this court.
Amend it first.
I'll amend
Amend
that.
the.
I'll
the
amend that.
plan.
I'll amend that.
Yes.
Not on the last date, the